you very much. Again, I'd like to join with others in welcoming the Minister to the House and welcoming our opportunity to discuss and debate these issues. As with others, I think it is a very welcome step that we are looking to legislate in respect of the access to information and for adopted persons and the exchange of information and better tracing mechanisms. I do accept and acknowledge that, but I will move to some of the areas of concern which are there, and I think some of them the Minister has already acknowledged. The Minister gave some history of the changing nature of adoption in the state. However, there is another aspect of that history of adoption in the state that perhaps wasn't as acknowledged. I know we will have a chance to discuss it later today, but it is important. There is a history or an aspect of the history of adoption in the state which relates to the experiences of forced adoption, the experience of adoption under great duress. We know about the 2,000 children who were adopted to the United States. We know of adoptions that took place when women were in situations of effectively forced detention. And there is a very difficult and problematic history of adoption, and that needs to be acknowledged, because in the discussion on balance that we're hearing today, we need to acknowledge there has been a deep imbalance given in this state. And in fact, the rights of the children adopted and their birth parent have often been very low in the balance of concern of the state and of those involved in adoption in the past. So I think it's important that when we talk about balancing those two elements, we recognise that they have both been subservient to other concerns in the past. And I think that's key when we look to the context. You have acknowledged, Minister, and that there are concerns in respect of the question of compelling reasons, the questions of clarity around that. And I expect as well, I would just acknowledge that my colleagues, Senator Lynn Ruane and Senator Colette Kelleher, would share many of the concerns I'm mentioning today, and we may all be putting through amendments at the later stage, so I hope we can work with you in relation to that. In terms of the questions of compelling reasons, the question of well-being, the life and health, and I think it is very well enunciated by Senator Warfield that there are, of course, compelling reasons and compelling concerns for adopted persons, indeed issues of life and death, where they may wish to be able to access their information around their birth and around their heritage. But I'm going to focus in specifically the issue which you identified, Minister, and I welcome it. You identified as being problematic yourself, the question of the no-contact undertaking. Which is there as a requirement at the moment, and it is a matter of huge concern. We know that persons have a right to their identity. We passed, if we want a recent mandate, a referendum in this state which affirmed the rights of the child, and under the UN Convention on the Rights of the Child, the right to identity is a key part of that. And an inherent part of that right to identity is the knowledge of your past and your family history. Section 41 right now, I believe, severely challenges and undermines that right. It disrespects adopted persons. It places them in a different situation. There is no other group of citizens in the state who must sign disclaimers and waivers and undertakings in order to access essential information, such as their own birth certificates. It's completely out of line with it. And I know that this is an issue which has been of concern, for example, at the UN level, where the Committee on the Elimination of Discrimination Against Women has asked the Irish state to justify that element in the proposed bill, which required surviving adoptees to sign a statutory declaration undertaking not to contact their biological mothers as a condition for gaining access. This was a concern at CEDAW, and in response, the state talked again about the right to privacy. Some have challenged that there is a blurring of the line between what is privacy and what is secrecy. And there is, of course, the right to a private life of a person, an individual who is seeking information. It seems extraordinary that somebody would be asked to sign and waive away their right to contact a parent as a default mechanism. Surely this is an interference in the private life of the individual who has been adopted. We don't interfere in the relationships between others. If there are situations of unwanted contact, we do have mechanisms such as our legislation in areas such as harassment and others. So there are mechanisms where unwanted contact is there. We do have barring orders. We have all those mechanisms. But the problem here is having this as a default, having this, and we talked about the presumption on information, but what we're seeing here is people being forced into a choice between identity and information. People who in many cases have endured great cruelty from the state, being asked to choose between their identity and their information. And that's and their right to identity and relationship and their right to information alone. It's really unacceptable, and I think we need to be very clear. Those who were adopted in Ireland are not supplicants or applicants to the state. They're not looking for charity. In many cases, they've experienced what charity has been amounted to in this state in the past and in its institutions and in other religious institutions in this state. What they are looking for is justice and their proper rights on the same basis as any other citizens. That's what we need to be granting them. So I welcome that you're considering that. I urge you to reform this area at committee stage, Minister, and we will certainly look to support you if you have amendments to that effect. So I'm going to moving on to another point in relation to this, which is the double clause. It seems to be we already have a provision, again a problematic provision, which allows for compelling reasons, which allows an individual to say that they have reasons they do not want their contact details shared. Why do we have that as one bar which is set, and then yet also have the no contact clause? Another problem with the no contact clause, which also relates to the concerns in relation to the register and the transfer of the register, is the presumption that if somebody has not actively indicated that they wish contact, and somebody is deceased, that if you have a situation where somebody has given no indication, the assumption would be that you would use the no contact clause in that condition. And we know that there are situations, for example, where women were told that their children were dead. There are many original birth mothers who are in the state who do not know if their children are alive or adopted, who may not be in contact with the state on an ongoing basis, and who have been given false information. These are issues which arise, so there's a real concern about that default presumption. There's also concern around the lack of original copies in terms of documentation. It is one thing to be able to, and I know you mentioned it, Minister, view your documentation, to view your birth certificate, view your papers, but to be able to obtain original copies. And that is important for people as they move on in their lives, that they would be able to have original copies and proper copies of their documentation. For example, if they make their lives in a new country, they should be having original and appropriate documentation. They should be able to use that on the birth certificate they recognise as their own. It can affect, I think, a document, an edited document from a statutory agency is not the same thing. So I think that's a concern I hope you might also be addressing. As I said, Minister, and really when we look to, the question is not for those who have been through the adoption system in Ireland to prove their trustworthiness. We need to move away from the stigma which has been associated with this area.
You're out of time.
I'm out of time. I come to my concluding point, but for the state to restore trust in its citizens in itself as someone that delivers justice. My final point is a point of commendation. I absolutely welcome, Minister, your proposed amendment at committee stage in relation to the National Archives. I think that those are an appropriate place for this paperwork and for these papers. I think it's appropriate, and I think we also need to acknowledge, as well as the concerns of all those individuals in terms of tracing and appropriate treatment of records, there is a duty for the state to be able to amass these and look to this in an appropriate way as part of our collective history and something that we could look at, and in particular the fact that where records have been inaccurate, that they would still be transferred and included. So I want to really commend that amendment, and I look forward to it, and I look forward to the next stage of this debate, Minister. Thank you.